Hello, my name is Nduka Njoku. I'm your lecturer for PEL 446, Law of Evidence 2. Today, we are looking at another topic in the Law of Evidence, and that topic is corroboration. At the end of the lecture, you will understand the meaning of corroboration. You will also be able to answer the question whether it is of absolute necessity that every piece of evidence must be corroborated. And if the question or if the answer is in the negative, then what are those circumstances in which corroboration is required? I hope you will enjoy the lecture. Thank you.
Then what are those circumstances in which corroboration is required? I hope you will enjoy the lecture. Thank you.
Once again, you're welcome to today's lecture. We are discussing corroboration. At the end of this lecture, you should be able to explain the meaning of corroboration, discuss the reasons for the principle of corroboration, and determine the cases in which corroboration is required. By corroborative evidence, we mean evidence which confirms or supports another piece of evidence on a fact in issue. Corroboration of a witness may be found in the evidence of another witness or in a document or other source, which may include the conduct of a person under previous circumstance. Such conduct may be an act by a person whose act or action is a fact in issue. So, corroboration may be oral, it may be by conduct, it may be contained in a document. Now, let's look at the case of R versus Dosey, where it was held that the accused admission in evidence that he had platonically fondled the child who gave sworn testimony to the fact that he had indecently assaulted her could be treated as some corroboration of her statement. In the case of Credland versus Nola, it was held that the fact that the accused had falsely, as he subsequently admitted, told the police that he had not left his house on a particular evening, corroborated the unsworn evidence of two children that he had been guilty of an indecent assault a short distance away from his home. In the case of Schofield versus Joseph, in that case, a mother alleged that in an affidavit proceeding, that intercourse with the respondent took place on the way home from a dance. The respondent denied in chief that he had taken the girl home after the dance, but admitted in cross-examination. It was held that his lie in chief corroborated the evidence of the woman. This shows that somebody's conduct can actually amount to a corroboration of a testimony. In a criminal proceeding, apart from supplying or supporting corroboration, such evidence must also implicate the accused. Apart from confirming that offense has been committed, it must implicate the accused and ensure that offense has been committed and link the accused to that offense. In the case of Ulubeka versus State, a court can and is entitled to act on the evidence of one single witness if the witness is believed, given all the circumstances of the case. A single credible witness can establish a case beyond reasonable doubt unless where the law requires corroboration. In the case of Ahmed versus Nigerian Army, the court held that corroboration is no more than evidence tending to confirm or support and strengthen other evidence sought to be corroborated. In considering whether evidence is corroborative or not, the court may take the evidence as a whole and not piece by piece, and suspicion cannot give such evidence the quality of corroboration. Now, the evidence which acts as corroboration must be independent testimony of the evidence it seeks to corroborate. That independent testimony may be direct or circumstantial. So that is the position of the law. And again, if we are looking at another issue in respect of corroboration, evidence which needs corroboration, can it corroborate another evidence in need of corroboration? Let's look at the case of DPP versus Hester, where it was held that evidence of a child may be corroborated by the unsworn evidence of another child and vice versa. In the case of Okoro versus State, the Supreme Court held that one accomplice cannot corroborate another where each is an accomplice of the accused in the same crime, and that the unsworn evidence of a child cannot corroborate the unsworn evidence of another child. Nevertheless, the Supreme Court noted that in some circumstances, mutual corroboration can be allowed. Now, we have stated that as a general rule, that evidence of one person can ground a conviction where corroboration is not required. That all that the court wants is the evidence that is reliable, that is of the highest probative value and relevant and admissible, that the court can convict on such evidence. Now, what then is the rationale for corroboration? The rationale for corroboration is that the experience of the courts and the general experience of human beings shows that it is always better to convict on the evidence of more than one person, and that an individual may not be reliable and may be serving his own purpose, and that a rogue may come and give evidence and the court will convict on the evidence of that rogue or a fraudster. So, generally speaking, it is better to convict on the evidence of more than one person. In the next slide, you will be required to provide answer to a class activity provided in that slide. Discuss the meaning and nature of corroboration under the Nigerian Law of Evidence. Let's look at cases where corroboration is required. One of such cases is in treason and treasonable offenses contained in Section 201 of the Evidence Act. A person may be charged with treason or with any of the felonies mentioned in Sections 40, 41, and 42 of the Criminal Code Act, cannot be convicted except on his own plea of guilty or on the evidence in the open court of two witnesses, at least one overt act or the kind of treason or felony alleged, or the evidence of one person, of one witness to one overt act and one other witness to another overt act of the same kind of treason or felony. Look at the case of Aru vs. Omishade. Also, if we look at offenses of perjury, as a matter of law, corroboration is required. This is contained under Section 202 of the Evidence Act. If we look at the case of the exception of exceeding speed limit contained in Section 203 of the Evidence Act, subsection 1 provides that a person charged under any road traffic legislation with driving at a speed greater than the allowed maximum shall not be convicted solely on the evidence of one witness that in his opinion he was driving at such a speed. Now if we look at the proviso to that section, it says, provided that the evidence of a duly authorized officer of the relevant authority who was at the time of the commission of the offense operating any mechanical, electronic or other device for the recording of the speed of a moving vehicle, the record of such device being additionally tendered in evidence against the defendant shall not require further corroboration. In other words, under this section, corroboration can be found in the recording of a mechanical device or electronic device. If we look at subsection 2 of that section, it says, in this section, relevant authority means the Nigeria Police Force, the Federal Road Safety Commission, or any other body charged with responsibility for offenses of speeding under the road traffic legislation. In other words, these are the authorities that are permitted to use such devices, such electronic or mechanical devices, where corroborative evidence can be found. Again, in cases of sedition contained in Section 204 of the Evidence Act, corroboration is required. In sexual offenses, corroboration is also required. Sections 218, 221, 223 and 224 of the Criminal Code. Those sections deal with defilement of girls under 13, defilement of girls under 16 and above 13, and of idiots. Section 223, procuration. Section 224, procuring defilement of women. Under those sections, nobody can be convicted without corroboration. Again, evidence of an accomplice requires corroboration. Nevertheless, the court can convict if it warns itself that it's not safe to convict upon an uncorroborated evidence of an accomplice. Unsworn evidence of a child needs to be corroborated. Section 209 of the Evidence Act. Although the sworn testimony of a child can ground a conviction without corroboration, but generally speaking, the courts are reluctant in convicting upon a sworn testimony of an uncorroborated testimony of a child. The court will be reluctant to convict upon an uncorroborated sworn testimony of a child. Another is breach of promise of marriage. In an action of breach of promise of marriage, the court will require corroboration. In the next slide, you will be required to provide answer to a question that is contained in that slide. Discuss the cases in which corroboration is required under Nigerian Law of Evidence. In this lecture, we have discussed corroboration, the meaning and nature of corroboration, and why the law requires corroboration. We have looked at those situations in which corroboration is required. I hope you have enjoyed today's lecture. Thank you.